Tanlo, come, come, come to Tanlo, Tanlo, to Tanlo, Tanlo, to Tanlo, Immigration and family law, employment law and corporate law, commission of votes and all the other laws, professional and friendly services we give you all. For all your immigration law, family law, employment law, business and corporate law, welfare benefits, charity law, will, commission of oaths litigation, come to Tanlo Solicitors or simply visit our website on www.tanlo.co.uk or simply call us on 024 776 32323. Tanlo Solicitors, professional and friendly service.
Welcome everyone to this episode, once again sponsored by Tanlo Solicitors. My name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors, and today we want to just celebrate some of the heroes that are amongst ourselves. And as you might imagine and know, today is the International Nurses Day, and we want to celebrate the nurses that is amongst us. This includes practicing nurses, nurse aides, carers, support workers, and I would want to say everyone indeed in the healthcare sector, even the people who provide businesses that cater for people in the healthcare sector. As I've indicated, it's the International Nurses Day, and our nurses have been on the forefront during the COVID-19 international lockdowns. Some countries still have lockdowns, some countries have eased the lockdowns, but the nurses and the healthcare staff still remain on the front of tackling and dealing with COVID-19 cases. And for that, we are just grateful for the work that they've been doing and that they continue to do, even with the risks that they put their lives on, so that the majority of people, the population at large, will be safe. I was listening today on news, and I have seen that even at the Brits Award, the celebrities were calling for the recognition of our frontline workers, including the nurses, to get an increase in their salaries. I understand that this was a 1% increment offer that was done, but I think they deserve more than that. And it was also being debated today during the Prime Minister question time regarding the salaries of the nurses. Having said that, as you know, I am a lawyer, and I do always want to tackle things from a legal point of view. I do not profess to know more about nursing itself or how people become nurses and what they do at their work. Although I do have quite a number of friends and family members who work in the healthcare sector. They've got friends who have got healthcare businesses as well. So I do have a practical experience of at least what happens to them, or hear what happens to them. So I normally get a few questions, and I also deal with issues relating to nurses per se, and also maybe other people who work in different jobs in the sense of the law, because wherever you are, there is law. And when someone is working, for example, in the NHS, on one side, there is the employment law, and then on the other side, there's the regulation or regulatory law. So I want to touch on, time permitting, both aspects of the law relating to nurses practicing in England. So nurses practicing in England are regulated by the NMC, and the NMC is there, as they say on their website, the professional regulator for nurses, midwives in the UK, and nursing associates in England. So they are there to regulate the practice, and they are there to protect the public. There is a complaints procedure that is there for the public if they want to complain against any practices of the nurses, and for the nurses, for you to become registered as a nurse, a midwife, with the NMC, there's processes and procedures that you need to follow. It goes without saying that you need to have the relevant qualification, and to my mere understanding, there is at least 3 ways which you can qualify to be a nurse in the United Kingdom. It's either you go to university, you do your qualification through the university, and once you get your university qualification, you can then go through the registration process with NMC. I also understand that through experience, if someone has been working in the healthcare sector for a while, they can be seconded by their employer, and the employer can then pay for their tuition fee and actually pay them to train. Because when you go to university, they will pay for your tuition. They used to pay a bursary, but the bursary is no longer there. So you need to pay for your maintenance and other costs. But if you are sent to study by your employer, then they can pay for your costs. You'll be on the salary as well. And you've got the advantage that you're working with experience, and some of the things that you are learning, you've already experienced them. When, for example, some people are struggling with work placement, you might not be struggling with work placement because you have been in the sector for a while. Of interest to me as well is people who want to come from outside the country to work as nurses. I do get a lot of these inquiries every day, especially these days with the new health and social care visa, which is there. And I've got I know of a number of companies that are applying for sponsor licenses so that they can be able to employ nurses, nurse aides, support workers from outside the country. And once they will have their sponsor license, then they can employ people from abroad, and hopefully ease any employment issues they might have vis-a-vis their employees. So someone can become a nurse in the UK if they've qualified from outside the country. There is a process that has to be followed in terms of the NMC. You need to go through your competence test. You need to do your qualification, which would have done abroad. And then after you've done your qualification from abroad, you then need to do the test of competence from NMC. And once you pass the competence test, then you can be registered as a nurse. In terms of the Home Office, you will need to pass the English test. You have your qualification, you have your police check report, you will meet the maintenance fee money, which is around £1,100, unless if your sponsor is A-rated. And if you're coming with your dependents, they also meet some requirements which they might meet, and your employer has generated a sponsor certificate for yourself. So once you become a nurse, then you are on the NMC register. You are expected to abide by a code of professional standards, and that is what most people fall short of when they are in practice. You are generally expected to be professional. You are expected to know what you are doing, to be competent, to have the necessary knowledge of English, and any act of misconduct, which is quite a wide word. There's a lot of things that an employer or the NMC can interpret as act of misconduct or criminal behavior, or even issues of your health might affect your workplace or your registration, and these are some of the things that the NMC will investigate. The Code for Professional Standards is quite a large document, and there's a lot of issues that the NMC might investigate. The investigation might be instigated by a complaint by a member of the public or a referral by your employer. So if those happens, then the NMC is duty bound to investigate your regulation and your fitness to practice. So basically, with the NMC, we are speaking about fitness to practice. If they doubt that you are fit to practice, then they have got different penalties, if I may use that word, that they might put on you. They might suspend you from practice, or they might remove you from the register. You might be required to do additional courses or to go under additional supervision and things like that. If you have been referred to the NMC, you will normally receive a notification, a letter from the NMC that you have been referred, and then they will ask you to give your side of the story whilst they are doing their investigations, and they'll give you a deadline to submit the information. If you cannot meet the deadline to submit the information, it's important to write to them to say you need more time to submit the information. If you don't have it, they are normally understanding, so that you can then submit the information if you can. If you don't have the competence to deal with the NMC, it's always important to instruct someone who can be able to help you. And normally you might by then be a member of a trade union such as RCN or Unison. If you are a member, then maybe they might help you at that stage, or if mostly they will help you. It just depends on the case. And if you are not a union member, then you might need to seek advice from legal advisors like Tan Law Solicitors. We've got specialists who deal with employment law and regulatory matters. So if you are dealing with an NMC matter, you can come to Tan Law Solicitors, and we should be able to help you or to assist you with any matter that relates to NMC. When you are preparing for the hearing, like I said, there's a letter that you receive. Then you do your representations to the NMC. If they want any clarifications, they will write to you, and then they will make their own decision. Once they've made their own decision, the matter can then go to the hearing. And in the hearing, there's normally a panel of 3 people, at least one of them being a professional nurse on the panel, who will then be the adjudicators for your case. There is also a legal representative who will be an advisor to the panel, and then the case presenter or the case owner who will be representing the NMC, yourself, and if you've got a representative, your representative. Normally, the NMC might have prepared a bundle, a joint bundle where all the information that they're relying on and all the information that you are relying on is in the bundle. And a copy of the bundle, you will have a copy of the bundle. The adjudicators, the panel, will have a copy of their own bundles. So as the case presenter and the legal representative, you are given a chance through your legal representative or by yourself to present your case, to cross-examine any witnesses, to re-examine your case, and so is the NMC given that opportunity, and ultimately the panel will make their hearing, I beg your pardon, their findings on the matter. It's always advisable to have someone to represent you or at least to accompany you, because most of the time you are under a lot of stress, you are under a lot of immense pressure. Maybe you're stressed and depressed because of what is happening. So it is always important to get someone who can reason objectively on your behalf, so that they can present the case better than yourself. And most cases, people are very emotional, and sometimes when you're emotional, you lose your rationale, and you do not really present your case properly. So in a nutshell, that is about the NMC, that they are there to regulate nurses, midwives, and nursing associates, and that a nurse is expected to abide by professional standards that are mentioned in the Code of Professional Standards. And if you breach the code, then you might be referred to the NMC to be investigated. And once investigated, you might be referred to the court or the tribunal, which will then make a decision on your case. And if you require any advice on this, you can contact me. Our details are on the screen. We can help you with NMC hearings or NMC investigations. Some people have got problems even with their DBS, and they're referred to the DBS where they're being, the DBS is minded to bar them from practice of anything to deal with the vulnerable adults or vulnerable people. We have represented people who have been in such situations where they're facing debarring from the DBS people, and we have been successful in some cases, reviewed or appealed some of the cases. As I said in my introduction, when it comes to being a nurse, there is, in terms of the law, in my view, there is at least two strands, and the one strand is the regulation, and on the other side is the employment. So the regulation really is to deal with the NMC. Then when it comes to employment, it's mainly you and your employer. So if you're working for the NHS, you need your contract of employment with the NHS. If you're working for a private company or a nursing home or the council, you need a contract. It is quite, surprising to know that some or a number of people don't know the terms of their own employment contract. They send a contract and they've not really read, or they've forgotten about the terms of the contract. And when the employer is raising issues against them, mainly it's coming from the contract of employment or any other subsidiary policies that they might have, like the grievance policy, the employment and the grievance procedures, or the other policies. One might be the health and safety policies, whatever policies are in the workplace. If you breach them, then the employer might have a right to come against you. And likewise, if your employer breaches the contract, then you have got the right to come against them. So it is important as an employee to know the terms and conditions of your contract. What does your contract say when it comes to holidays, when it comes to discipline, to grievance procedure? What does it say when you are dealing with issues relating to promotion and so forth? So you need to know all these things so that when there is an issue, you should be able to raise it and to be able to address it. Some of the issues that we have had when it comes to employment are issues to deal with breach of contract, where you believe that the employer has breached their contract. It could be the NHS, or it could be a local council, or any other employer in the healthcare sector. If they breach the contract, if, for example, they are not giving you your holiday, or they are refusing to give you a holiday, or they are unlawfully deducting your salaries, you do not understand how they're deducting your salaries, that can be an issue that you can raise against them. Or some of the issues that we have heard is of discrimination, and discrimination can come in various ways and forms. It could be because of sexual orientation, race, nationality, religion, and so forth, maternity, pregnancy, and things like that. So we deal with racial discrimination cases. We have dealt with cases of unfair dismissal, where you believe that you have been unfairly dismissed, or constructive dismissal, where the conditions at the workplace are so much that you cannot continue to work for for that particular employer, but you have maybe to tender a resignation in protest most of the time, and then you have to seek some legal address to whatever has happened. So if you're experiencing any issues at your workplace relating to your terms and conditions, or if you are facing any discrimination, or you've been unfairly dismissed, or you are being victimized for anything in the workplace, there are people who are just victimized. If you did whistleblowing in the workplace and now you are a target of the management or the employer, then we should be able to assist you. You should go to work and like your work and enjoy your work. If you're not enjoying your work, then there is issues or problems with your work, and those things need to be addressed. When it comes to issues of grievance and employment issues, most of the time the starting point is for you to follow the policies that are there or to follow the terms in the contract. And in most circumstances, you raise a complaint to your line manager, and then the line manager can deal with the issue. If the line manager cannot deal with the issue, then they have to escalate it to the next person above. If not, you can escalate it yourself, and ultimately until it gets to the person who ultimately has the main decision, which might satisfy both parties. If you're satisfied with the resolution that has been offered, that's fine. If you're not satisfied with the resolution, then you might take the case further. You will note that when it comes to disciplinary hearings or grievance hearings, most employers don't allow solicitors to attend grievance or employment disciplinary internal hearings. So it is quite important for you to be a member of a union, because you're allowed to bring a union member to a disciplinary hearing or to a grievance procedure. So if you're a member of Unison or RCN, you might invite them to come along. You're also allowed to bring a family member or a friend or someone who can support you during these hearings of disciplinary hearings and grievance hearings. Most companies have got the initial hearing, and then they've got their own internal appeal process. If you exhaust the internal appeal processes, then you need to go outside. It is important to note that most cases you've got a 3-month limit for you to go to the employment tribunal. So whenever that issue has arisen, if it's things of, say, discrimination, it could be 3 months from the time of the discrimination itself. But if it's things, some other things, it could be that from 3 months from the date of the resolution that was made by the company as the final resolution. And within the 3 months, you can approach ACAS, ACAS, so that they can mediate in your case. When you go to ACAS, the main aim of ACAS is to try to resolve employment matters before they go out of hand or before they go to an employment tribunal. In most circumstances, people can come to a solution through ACAS. You might be paid damages, or you might be reinstated to your workplace, or you might get whatever resolution you were seeking. If there is no resolution that is satisfying you, then you will need to submit your ET1 in the employment tribunal, and the respondent will then have their opportunity to submit their ET3 in response with their defense. You submit your particulars with your ET1 form, and again with the certificate from ACAS that you approach ACAS and there was no resolution. They will generate a number, a certificate, which you then submit to the employment tribunal together with there's a section in the form where you have to put that number. So once you go to the tribunal, ACAS can still continue to be involved in case you might want to mediate and to negotiate and come to a resolution. and maybe you come and you do a settlement, you do your COT3 settlement, which is normally you agree to a settlement, they agree to give you a good reference, you agree not to keep it confidential, the agreement that you have done, and that it is the end of the case. You will no longer raise any other issues against the company in the future, and so forth. But if you decide to press on for your case in the tribunal, as I've stated, you submit your ET1 and your particulars of claim. The respondent submit their ET3 and their defense. There is a case management hearing that is set up where you will then decide on the issues, the likely, you put in you put on the issues that you're going to deal with, and also the costs and the claim that you are dealing with, the schedule of loss that you are going to deal with, and so forth. If you agree on things, that's fine. If not, if you disagree, that's fine. You then proceed. If you are a self-actor, and in most cases anyway, the company, the respondent, is asked to do the bundle. You give them the information, you exchange statements, and then a joint bundle is submitted to the court, and the court will then allocate you a hearing. It might be 1 day, 2 days, 3 days, depending on what the court estimates will be the issues. And once you have submitted the bundle, you then have to attend court. Remember, all the time, negotiation is always open. And most of the time, you will see that the respondent, if they feel that the issue is so minor, or maybe they are going to lose in court, or maybe the costs are more than what they are going to incur, most likely is going to be more than what you're claiming yourself, they might still continue to offer to settle the case. Now, so you might find them trying to settle a week before, even a day before, even during the hearing. If it's a hearing for about 5 days and you've done a single day, and then they might still continue to offer. And if you refuse to accept an offer that is considered reasonable by the court, then the court might, penalize you for that, and in terms of costs and so forth. Although most of the negotiation is made on a without prejudice basis, that means that the details of the negotiation should not be disclosed to the court or remain confidential, unless where someone is indeed acted unreasonable, where, for example, the court makes an award of the same amount or a similar amount than that the respondent was offering. So I was at that stage when I was commenting on you in the hearing. You will be led into evidence by your advocate or your counsel, and you will be cross-examined by the respondent. Your same applies to your witnesses, and then the respondent will have the same process. The judges and the other side can ask questions as much as they want. You might have a single judge or a panel of judges in the employment tribunal, and it's also important to realize that the employment tribunal has got its own jurisdiction of cases that it can hear, and above a certain figure of amount, it might have to go to a county court, or certain topics which might fall under employment because of the figure might have to go to a county court. So it is important to have a solicitor or a lawyer who understand these things, so that they will know which court to approach. Is it the employment tribunal? Is it the county court? But most cases it will be the employment tribunal. There's no court fee to pay in the employment tribunal. And you have to always bear in mind that there's always an issue of costs when it comes to employment matters. So you have to really believe that your case is a very strong case to go to the employment tribunal. The employment tribunal judge can make a decision. If you're happy with the decision, that's the end of the story. If you are not happy with the decision of the judges, then you can take the matter further, subject to merit. You can make an application to do the next employment appeal tribunal and EAT, and you can go further. It can end up even in the Supreme Court, depending on the issues and the merits of the case. Really, not so many cases will continue after the employment tribunal, but it's subject to assessment. So, in a nutshell, that is about employment and regulation, particularly today, targeting the nurses, midwives, and nursing assistants, our heroes that work in the healthcare, who are dealing with COVID issues, who are there to help us when we are in time of need, when our health is failing us. These guys do not fail us, but sometimes the employment environment is not so good, and then unfortunately they have to deal with employment matters as well, and also NMC. Well, I was about to say CQC. No, not CQC. NMC is there. I know that nurses do feel that the NMC is like a hammer waiting to fall down on them, even for the simplest mistake. There's a lot of things that they can face. It could be, you mistakenly gave someone medication, or you slept on duty, or the topics are quite wide. Why so many people might face investigation and ultimately sanctions from the NMC. If you want our details, they are on the screen. Someone is asking about our details. It's Tanlaw Solicitors. The mobile number on the screen is 074-214-29338. Comes direct to me. Or if you want to come through the office number, I'll just put it in for you now. The office number. The office number is 02477632323. That is our contact details. If you have got any questions that I can deal with in the next coming 10 or so minutes, if there's any questions, I can continue on this topic of employment for nurses, midwives, and nursing assistants. Okay. It seems I don't have any questions coming from the people that are viewing the show today. So if you need any assistance in terms of employment law, regulatory law, immigration, we can assist and help you. It is also important maybe to note that in the Queen's speech, there were some issues relating to immigration as well, and some changes of the law that I might comment on sometime next week, or maybe tomorrow on a different platform. But if you require immigration advice, employment advice, civil litigation, if you are having problems with your neighbor, for example, or the garage where you took your car, or a workman who came and did work at your house and you were not happy, things like that, we can assist you. Civil litigation, we also draft wills, and we help people to register their charities as well. We do help businesses and corporates. So if you're interested in our services, you can contact me, and my name is Andrew Nyamayaro, or you can call us on our office number 024-7763-2323, and mobile number or WhatsApp number 00447421429338. Thank you so much for watching today, and we will meet again sometime next week. Thank you.